Welcome to the Prudent Money Radio Show. I'm your host, Bob Brooks. Thank you so much for joining me today. You know, I do appreciate it. Well, about 50% of cases involving stepmothers and stepchildren run into problems when it comes to resolving estate issues. Attorney Michael Hackard is joining us to talk more about this situation, as well as the problem of elder financial abuse. He's also the author of a new book out, The Wolf at the Door, Undue Influence and Elder Financial Abuse. Michael, welcome to Prudent Money.
Oh, thank you for having me on your show, Bob.
Michael, blended families offer a really potential toxic combination of problems when the dad or the husband pass away. You know, first, let's identify some of the reasons for these statistics. Why is it that more of a reason to deal with the stepmom than the stepdad when in these court battles?
Well, it's a great question. And since we all have good friends or maybe stepmoms ourselves, it isn't to beat up on stepmoms, but it's a matter of statistics and demographics. There are 11 million widows in the United States and just a little less than 3 million widowers. So it stands to reason that when they're going with that estate problems with the blended families, that it's going to be much more likely that the stepmom is involved. There's some other statistics, and one of them is that only about 20% of stepdaughters get along with their stepmothers for whatever reason, but nevertheless, it's there, and so there are tensions having to do with the blended families.
Well, you know what's interesting in your book? You talk about that it really doesn't matter whether or not the stepchildren and the stepmom have a good relationship. And I would have thought different. I would have thought, well, maybe they have a good relationship. You don't get into some of these legal fights, but there's still a high probability that these fights will take place.
Yeah, I certainly see it a lot in our practice, and I do get calls from all over, certainly all over California, where I mainly practice, but actually from all over the country over these issues. It's a major problem because what happens is that usually let's assume that it is the husband who dies first and the stepmother is the survivor. So you oftentimes see a change in the estate plan after the husband dies. And we're involved in so many of these where the stepmother has changed the estate plan to favor her own genetic children and to freeze out or to just provide a minimal inheritance to her husband's genetic children.
Now, I can imagine that the toxic combination of a short-term marriage where the stepmom hasn't been a part of the family seems like it would always be the start of a nest.
Yeah, I agree with you, Bob. There is incredible toxicity in the short-term marriage because oftentimes that marriage occurs with certain skepticism on behalf of the genetic children anyway. And at that point, oftentimes you have a trust or an estate plan that's been in place for 30 or 40 years. And so as you know, if the husband is very ill and of declining cognitive ability as well, and you see some of these dramatic changes, and I've seen them before in the last days of life, but certainly in the last months of life, there's a great skepticism of what's happened that the genetic children are going to look into, the husband's genetic children.
Now, you write in the book that disputes can start almost immediately just based on where the body is buried. Not a good sign of things to come in that particular situation.
No, that's not a good sign of things to come. And I mean, you see different types of things associated with it. Among them is that it may have been the husband's expressed wish throughout his life that he not be cremated, and the stepmother chooses cremation. I've seen that many times. Or he's cremated and the stepmother won't release his ashes to the children or won't release some of his ashes. The other thing is at funerals where let's say that the genetic children are frozen out of participating in the services or helping to set up the services. And of course, there are enough cases too where they never even hear about the services. So again, I'm picking on stepmothers. I don't really wish to, but I'm relaying information that I have seen from my practice and that's fairly common.
I think that the bottom line is whether it's whoever's the surviving spouse, it really comes down to taking action while everybody's still alive and everybody is in fairly good relationships. Because that's one of the things that in working with people that I see is that they need to. And it's something as simple as putting a will together, maybe not as complicated as a blended family, but even putting a will together, it's kind of one of those things. Yeah, we'll get to it. I need to get that done. And they just put it off, and I'm thinking, boy, what if something were to happen? What a mess you'd have.
Yeah, what a mess you have. And of course, there are about half of the people that have stepchildren don't have wills. And almost a third of parents with 70 and over don't have wills. And that truly is just an invitation to a great disruption.
Michael, tell me this: is in a situation where you do have the blended family, is there something that the dad or the husband can do that is just ironclad? As ironclad can be, that you can avoid the disputes in the future upon a death.
Yeah, probably the better way is that. First of all, that Bob, you've identified it, transparency. So start with letting your children, whether it's your stepchildren or your genetic children, know what the plans are, and identifying where those plans are located, because oftentimes after someone passes away, that no one can find the estate plan. Oftentimes, too, it's going to work better if at the first death that at least if it's a trust, that some part of the trust, usually half of the trust, becomes irrevocable. And at that point, the children's benefits or inheritance is frozen in, even if they don't receive it immediately. Because if it's not irrevocable, then the survivor inherits everything, basically, and has all the rights or beneficial rights to everything. And it's just so easy to make those changes at that point to ultimately favor genetic children of the survivor, or sometimes what you see is that survivor remarries and the new spouse gets the benefit of the old spouse's estate.
Michael, I was thinking about it as you're talking about the word transparency. What an important word when it comes to this whole process. Have you watched as parents have used the estate plan or the will as a financial weapon? They want to write a child out of the will, out of the estate. They don't tell them about it. I mean, what a recipe for disaster.
It is a recipe for disaster. Sometimes they hear about it and sometimes not. Again, the incidence of writing a child out it's much higher when there's it goes higher with geographic distance. So it's probably out of sight, out of mind. So that's a problem. And of course, if someone is taking advantage, let's say someone who's closer to the elder is taking advantage of that elder, that's played up as well. Like, well, Susie never comes out to see you, and if people have dementia, fairly serious, even if Susie's coming out to see the parent, they may not remember it at all and might well believe that, oh, Susie's not seen you for 3 years. And we have tried some of those cases.
Talking to Michael Hackard about his book, The Wolf at the Door, Undue Influence and Elder Financial Abuse. His website, if you'd like to go to it, is www.hackardlaw.com. Now, Michael, of course, the book is about elder financial abuse. You see these cases, I know, very frequently. How bad a problem is this?
Well, it is a very significant problem. And there are a lot of studies, and of course I see it anecdotally, but there are a lot of studies that only 1 out of about 44 elder financial abuse cases are ever reported. and 1 in 9 seniors report being abused in some fashion within the previous year. So it's a major problem, and part of it I'll take uh, some of the guilt for it because I'm a baby boomer, and there are about 65 million of us. And, and there are about 10,000 people every day that turn the age of 65. And dementia, of course, increases with age. At 65, about 1% of the population has it. But by the time you're 85, 30, I don't know why there's this disparity in the study, but there's 30 to 45% of the people that are 85 have it. So people with dementia get taken advantage of.
Now, you write in the book, and you kind of mentioned about the guilt, that surviving family members often have a difficult time picking up the phone and calling an attorney about an elder abuse case. Talk about what they're going through.
Yeah. It's timely because certainly several times a week, I get calls from people that a parent has just passed away and they just found out that their brother or sister got the parent during the last days or last months to change over a trust or a will and leave everything to that person that exercised undue influence. And it's tragic because, and I think I know you talk about this at times, but grief does strange things to us. It doesn't matter whether it's me or you or the listeners, and we don't know what grief is going to do to us. Sometimes it's anger or it's other things. And so people will call up often in just amazement that a family member would do this, but then full of grief, feeling like guilty. Well, they might feel guilty. Well, why would my parent do this to me? Or might also feel guilty, like, oh, I should have been closer. I should have been watching out what was happening with my parent because he or she clearly weren't in their right mind. So there is just a lot of guilt that goes with it.
Just out of curiosity, you include a verse out of Proverbs, verse 29:18, without a vision the people perish, in the beginning of the book. Talk about the significance of that verse and why you put it in the book. Out of curiosity.
Well, I've always loved that verse. I think it's so telling, and I know Lincoln used that verse in the midst of the Civil War. I think it is so important that we work to have a vision, whether that's through prayer or other guidance, that we work to have a vision to do better, to do good. And if we don't work on that vision, then we're just going to battle in our lives, and we're not going to have hope. And not be going to understand that some of the suffering that we have today can be alleviated or can be utilized for the good. When I speak to lawyers, my own version of that is that I say that in our profession, we really should be a force for good, not for evil. And there's a lot of good that we can do as lawyers. And of course, a lot of times people see lawyers in a negative light, and maybe that's justified, and maybe it isn't. But nevertheless, we as lawyers should work toward doing good.
Now, Michael, you mentioned undue influence a little while ago. Talk about how that works when it comes to elder abuse.
Well, the elder doesn't necessarily have to lack capacity in order to be unduly influenced. And the basic definition of undue influence is excessive persuasion to cause another person to act or refrain from acting by overcoming that person's free will and ultimately resulting in inequity. So you always start with a vulnerable senior elder, so someone 65 and above. And that person could lack capacity, but more often than doesn't, or will not, or will have capacity. But there's an illness or a disability, an injury, or simply age or emotional distress, oftentimes grief. And oftentimes that person is isolated against his or her other loved ones by the person that is utilizing undue influence. And then some type of tactics are used to do it. And normally it's some kind of secret tactic, taking the elderly parent to a lawyer, not telling the siblings about it. And ultimately, the result of if there's undue influence and nothing really happens, well, it's not going to be something that's going to be litigated over. But when you get an unequal result, that's when it's going to be litigated. That sister gets, parent to give 100% of an estate to her, or even, 5 siblings and sister gets 60%. Well, those that have the remaining 40 aren't going to be too happy.
Yeah, I was just thinking about what a delicate situation this is, and the importance of a book like that you've written, The Wolf at the Door, Undue Influence and Elder Financial Abuse, and where you really talk about a lot of the cases, a lot of the situations. I think what ends up happening, and I think you would agree, is that adult children get busy with their own lives, and they maybe make some mistakes. First of all, they assume that this would never happen, especially a sibling getting involved in the elder abuse type situation. And they're just not paying attention to the details. And you write in the book about a lot of the details. I thought we'd talk about some of this. Talk about when it occurs with a caregiver, because that's one of the things you just think would never happen.
Yeah, caregiver abuse, financial elder abuse, is very common, and we have a lot of those types of cases. And it usually occurs near the time where the senior's dying or close to death. You normally don't see caregiver abuse, 5 years before a senior dies. You see it in the last months. And it's oftentimes you'll see the caregiver freezing out other relatives, both by telephone, like people call and the caregiver says, "Oh no, she's not available because she's asleep, or she doesn't want to talk, or she just is not available right now." And even when people show up at the door, you see the same thing. And caregivers are, have an elderly adult who is near life's end, and who is completely dependent oftentimes on that caregiver. So that elderly adult is not thinking about, I have $1 million or $2 million in the bank. They're thinking about, I hope this caregiver will take care of me today and tomorrow, and I won't be kicked out of my home. So you see these extraordinary gifts oftentimes over to caregivers during the last weeks or days or months of life.
This is Bob Brooks, and you are listening to the Prudent Money Radio Show. Thank you so much for joining me today. I do appreciate it. Talking to Michael Hackard about his book, The Wolf at the Door, Undue Influence and Elder Financial Abuse. If you want more information, you can go to this website at www.hackardlaw.com. Michael, you write about financial exploitation and that it takes on many different forms. Talk about, a couple things. Talk about the more common forms that you would see, and then maybe the one that surprised you, that you go, wow, I haven't seen that one before.
Well, a common form is a power of attorney form. And normally a power of attorney is given to a close family member. And oftentimes it's given, there are two different types of power of attorney. One is called a springing power of attorney that basically says this doesn't cut in or is not effective until the maker of the power of attorney is incapacitated. Others are called durable powers of attorney, which basically says, no, that this is effective immediately. So what happens with power of attorney abuse is you can actually, if you have a power, if you're the holder of a power of attorney, you actually can have power over transferring someone's house or bank accounts or other assets that they have into your own name or into other family members' names or whoever it is that you want. And the senior oftentimes is just going along and not really asking for an accounting and just figuring that whoever it is that has their power of attorney is not abusing it. So that is very common. Now, powers of attorney end at death, and so oftentimes you don't see its effects until deaths and find out that accounts have been looted or even houses transferred. That's one area. The other area is trust abuse, where maybe someone has been appointed the trustee of the maker for the maker of the trust. The maker is still alive, and you can see abuse of bank accounts there. You also see at death a trustee, a successor trustee to the maker, not disclosing information to the beneficiaries of the current trust or maybe of a previous trust before there was an abusive trust put in later. Another common occurrence. And now you ask, am I was trying to think when you said, am I ever surprised? I think I'm in my 42nd year of law practice, so maybe I don't get as surprised as I used to. Yeah.
Fair enough. Let me ask you one more question. We got a couple minutes left. Because I'm real curious about this, because what a sticky situation it is when one adult child discovers that a sibling has been the abuser the entire time. Now, how many of these situations occur where the sibling presses charges or files for legal matters against the sibling who was involved in the abuse? Because I could see it both ways, where you maybe don't want to go there, but boy, maybe you're mad enough to go there.
Yeah. Oftentimes you'll see reports to Adult Protective Services, and they're kept track of. So the non-abuser would report the abuser, but it's really rare that even with Adult Protective Services that wrongdoing is stopped. And the reason why is basically it's a APS, for the most part, they do a lot of good work, but they're restricted. They go and knock on someone's door, say a senior's door, and say, are you all right? And if the abuser's around, they'll try to get the abuser to go in the other room. But for the most part, seniors aren't going to say, no, I'm not all right, and my child is doing this to me. And then progressing up to the criminal side, I oftentimes get asked that. Now, people say, I want to go to the DA or I want to go to the sheriff and report this. Unfortunately, you don't see them take many of the cases. And the reason why is they have a different standard of review, and they have because in order to prosecute someone, they've got to look at it and say, can we prove this beyond a reasonable doubt, versus the civil side, which is just more likely than not. So they'll look at things, and they have good investigators, but it's a much higher standard of proof for them, and it's tough to get it into the criminal side.
Well, Michael, congratulations on your book. Once again, The Wolf at the Door, Undue Influence and Elder Financial Abuse. You can get more information at hackardlaw.com. Michael, it was a pleasure to have you on the program.
Thank you very much, Bob.